Welcome to the EJF Learning Series. I'm your host, Sarah Keller, the Director of Community Managers at EJF Real Estate. Today I have Brett Herbert and Todd Sinkins from Whiteford to present on conflict resolution and working with divided boards. This session is being recorded. The recording and slides will be circulated after the session. At the end of today's presentation, we will leave time for a Q&A. I will now turn things over to Todd. Take it away.
Well, thanks, Sarah. Appreciate that. So this presentation is going to provide some guidance for boards about how to deal with each other when you're not all in agreement, when there might be some conflicts or adversity amongst the board members. And our goal here is to provide the board members with some tools that they can use to attempt to reach some commonality and deal with each other in a professional and respectful manner with an understanding that you're not always going to agree with each other. These are issues that Brett deals with regularly in his practice based in the Richmond area, and that I've been dealing with for over 25 years in my practice, which is based in Northern Virginia in the District of Columbia. And so with that, Brett's going to take it away for the first series of slides. Thank you.
Thank you, Todd, and good afternoon, everyone. We appreciate the opportunity to present to you today. Look forward to your questions at the end. So my name is Brett Herbert. As Sarah and Todd mentioned, I'm a partner at Whiteford, Taylor & Preston, based out of the Richmond office, which is primarily where my practice is. So as we get into these issues today, it's very helpful to give some background, even a refresher for some, on the basic obligations and duties of members of the board as we lay the foundation for these tools in dealing with divided boards. So as directors, members of the board, obviously you all are volunteers, and as you go into service of your community association, you all have probably already encountered that it's not always the most appreciated job. You deal with some difficult issues. You deal with difficult owners from time to time. And there's always going to be this delta, this discrepancy between the ideal board situation and the reality. All members of the board come from different circumstances. They're unique individuals, and coming together to carry out your fiduciary duties, your obligations as members of the board to best serve your community can be difficult and can be a trying effort and circumstance and situation at times. And so this presentation is really geared, as Todd said, towards giving you all some practical tips on how to handle those disputes and those issues that will inevitably arise. So Sarah, we can go to the next slide if you could, please. So speaking today specifically about divided boards, it goes without saying that some potential situations that could cause some problems with divided boards or common circumstances where we see issues is you could have a situation where a minority group of directors on the board are acting to undermine the vote of the majority of the board. For example, if the board votes to take a certain action and there are dissenters, are there certain dissenting directors who may be working to undermine that decision or who may not fully back that decision of the board? That can be very problematic, and we're going to be getting into that as well today. It could be a situation where a majority of board members are marginalizing or trying to shut out a minority of members of the board, either in discussions or getting their opinions across in board meetings, things like that. And oftentimes we see situations where there may be personality problems that may exacerbate that particular scenario. And when you're dealing with divided boards, ultimately it's difficult for the association to carry out its business, but it can also lead to members and owners losing faith in the board, beginning to second guess whether the board members are competent to actually carry out their duties. So Sarah, we can go to the next slide, please. So as you all probably know, as a refresher for some, maybe informational for newer members of the board who haven't yet had full board training, board members of community associations are what are known as fiduciaries. And we're going to get into what that means and what those duties are in a few slides. But this slide really, when we're talking about a split vote, it is perfectly feasible for a situation where board members aren't going to unanimously agree on everything. That's perfectly normal. But where you run into some issues is where board members who dissent from a majority vote of the board potentially work to undermine or not get on board, for lack of a better phrase, with the board's decision that is made. So it's important to remember and also make sure for your boards that the board itself as a whole, all members of the board need to respect the decision of a majority of the board. And so if a decision is made, even if there's fervent discussion and dissent from certain members of the board, once the decision is made, those members of the board need to respect that decision, even the dissenters, and work not to undermine that decision, but to carry out the board's business and decision in that respect. And Sarah, we can go to the next slide. So as we mentioned, members of the board are known as fiduciaries. So a fiduciary duty, these are certain duties that are imposed on the individual members of the board. They are owed directly to the association itself. And we're going to get into specifically what those mean here in a second. These duties can be imposed on the members of the board either by statute in your particular jurisdiction, or the common law, that is judge-made law or case law in your particular jurisdiction. And they're certainly very serious. It's the highest standard under the law as far as a duty that is owed by a person to another. And it's definitely something to take very seriously, but at the same time, it's not something that members of the board necessarily need to be afraid of. It's something they need to understand and make sure that they carry out. And so some summaries for what these fiduciary duties actually mean, and we're going to get into them in more detail here in a second. But generally speaking, we're talking about things like not taking advantage of one's role as a member of the board of directors, disclosing any interests, or there's a conflict of interest between a member of the board and some issue that the board is taking up. There's an obligation to disclose that. And so it's important for members of the board to make sure they understand the various fiduciary duties that are imposed on themselves and under other members of the board, but also to be vigilant when other members of the board may not be carrying out those fiduciary duties. And it's important for those members of the board, all members of the board, not to tolerate a director who's not carrying out his or her fiduciary duties. So if there's inappropriate behavior, if there's a violation of a particular fiduciary duty, such as the duty of loyalty or the duty of confidentiality, those other board members need to take action, need to speak up to try to rein that behavior in. And we're going to talk about some tools for that here in a minute. So as fiduciaries, the members of the board are considered stewards over the property and funds of others, the assessments, the association property, these sorts of things. And fiduciary duty is sort of a broad legal term. And in this context, it relates to the individual members of the board's duty of care and duty of loyalty. And so the duty of care and duty of loyalty, we'll get into what that means here in the next slide or two. But as mentioned before, the fiduciary duties that are imposed on members of the board, fiduciary duties generally are the highest standard of care under the law. They're higher than the standard of care for, as compared to, let's say, a grocery store to a customer coming in who may slip on something in the aisle. The standard of care for that store in that circumstance is not going to be a fiduciary duty. There's still duties imposed on that store, but the fiduciary duty with respect to members of the board, again, is going to be the highest standard of care that's recognized under the law. And again, we're going to get into what that specifically means on these specific duties in a moment. And the fiduciary duties that the members of the board owe are owed to the association itself as a whole, and not specifically to the owners themselves, although that is state specific generally. So we're speaking kind of generally today, but as a general matter, it will be owed to the association itself. And for members of the board, the best interests of the association need to be the guiding criteria when carrying out these duties, obviously not one's personal interests. So getting into the duty specifically, the duty of care can be summarized generally as follows. It's the duty not to be wasteful of association assets and resources. It's the duty to be informed of issues that the association is facing. It's the duty to read board packets, to read materials that are provided to the board from, let's say, experts like attorneys or community managers or accountants. And it's the duty to utilize those materials and to make careful decisions, to carry out your duty to make those decisions in an informed manner. And the opposite, the illustration of what not to do is to not do those things, to stick one's head in the sand, not read board packets, not read what the attorneys or the community managers or the accountants are providing, and to not make careful decisions. That's what you want to avoid. That's very likely a violation of the duty of care. These are things to be avoided. And as members of the board, to be on the lookout for what other members of the board may be doing. And if they're doing those things or not engaging in those careful decision-making processes, that's a problem and something that needs to be taken up. So to close out the duty of care, there's also a duty of inquiry, and that's sort of a duty to be informed of what's going on, a duty to keep in contact with the community manager, a duty to read one's emails about association business, and if there are issues, to look into them and not to ignore them. The duty of loyalty can be summarized as a duty to act in good faith and in the best interests of the association, and critically, to put the association's interests ahead of one's own. And a part of this duty of loyalty is this duty of confidentiality that also arises with respect to members of the board. And as part of the duty of loyalty, there's also the duty to ensure that the association's obligations are carried out. And on the duty of confidentiality, this can be sort of further amplified that board members generally need to keep confidential information confidential, especially as it relates to legal advice, legal strategy on issues. The board members are obligated to protect confidential information relating to individual owners. And importantly, the duty to protect and preserve confidential information received during one's service as a director continues even after the director leaves the board. And so as we talked about a bit earlier, the conflict of interest issue, if there is a conflict that a director is facing or a potential conflict, that director really has the obligation to disclose the conflict and to recuse themselves from the discussion and votes on those particular matters on which they have a conflict. And that can be a bit uncomfortable sometimes if that particular director doesn't do that voluntarily. It can fall on the other members of the board to ask that director, hey, in light of this conflict here, you really need to recuse yourself and not vote on this issue. And depending on the reception that director gives in response to that request to recuse oneself, sometimes it's necessary to get legal counsel involved to sort of talk through that issue with that conflicted director, to ask them to actually do that, to explain the legal liability and the potential issues that are raised. And sometimes, unfortunately, it does come to that. And Sarah, we can go to the next slide. So the next slide's on the business judgment rule. My colleague Todd actually just presented on this topic last week nationally. So I'll turn it over to him. Todd?
Yeah, thank you, Brett. So, the business judgment rule is the standard that evaluates whether a director has complied with their fiduciary duty. It is typically incorporated by common law in essentially, I believe, every state in the country at some level. And by statute in some jurisdictions, including the District of Columbia as it applies to condominiums, where the business judgment rule is statutorily incorporated as the standard to evaluate decisions by boards. So the business judgment rule looks at two different issues. One, did the board, and I'm actually going to go through this in sort of the reverse of what they're shown on the slide. One, did the board member have the authority to act in the way that they acted? For that question, you look to the governing documents, you look to statute. if the statute and the governing documents for the community provide authority for the board to act, they'll act. Now, keep in mind, sometimes that authority is going to be broadly defined. For instance, for, in bylaws for, homeowners associations and condominiums, you'll often find general authority for the board of directors to administer the affairs of the association and take all actions that are not delegated to the owners, for which the owners would have authority to vote. So that generally creates really broad authority, and particularly when you're dealing with a incorporated association, you're also going to look at the corporate statute, and usually that corporate statute grants to the board very broad authority to act. But you do need to understand, when a board member might be exceeding their authority. Assuming that the board member has the authority to act, then the next question a court's going to look at is, did they exercise the care and skill of an ordinarily prudent director? What does that mean? It means, essentially, was a decision made by an informed, prepared director? Did they, Brett talked about the duty to inquire and be informed earlier. That's critical to any board member's decision-making process. So how do you meet that? First of all, you attend meetings. You read your board package prior to the meeting. You're familiar with the documents that are going to be discussed at a board meeting, and also familiar with the applicable provisions of the governing documents. If it's something that requires particular expertise, then you seek out that expertise. You consult with management. You consult with other expert consultants, such as engineers, accountants, etc. You consult with legal counsel if it's a question that relates to the law. And doing that not only allows you to meet this standard, but also provides another layer of protection to a board member. The law recognizes as a defense to a breach of fiduciary duty claim that when the board member relied upon the advice of counsel or other experts and made a decision based upon that advice, and that is a defense to a breach of fiduciary duty claim. And so when I'm talking to my clients and advising my clients, one thing I will always tell them is that, listen, if you do not believe you have sufficient information to make a fully informed decision, don't vote. Don't make the decision. Get the information you need so you understand it. You need to understand the decision you're making before you make it. And if you don't believe you're in a position to do so, table the issue to the next meeting. Go to your manager and say, listen, we need this additional information before we're comfortable making a decision on this. And don't be afraid to do that. Next slide, please. So vicarious liability. This is the concept in the law where the actions by board members can create liability for the association. And it extends beyond board members. It also would apply to committee members, both official and ad hoc. The concept is that when a representative of the association is interacting with some third party, be it a contractor, an owner, somebody, that their actions and statements are going to be found to be binding on the association because that third party has a right to assume that that person who's representing the association is speaking for the association. There's actually a case out of Northern Virginia that was it's close to 30 years old now, but it was heard in the Fourth Circuit Court of Appeals and involved a condominium in Northern Virginia called Watergate at Landmark. And in that case, the association created an ad hoc committee for the sole purpose of conducting screening interviews. Watergate at Landmark's a large condominium, over 1,000 units, and they have a large set of amenities, including a number of tennis courts. And at least in the 90s, I don't know if it's now, they had a tennis pro on staff. And they decided that they were going to look for a new tennis pro, but allow the incumbent tennis pro to reapply for her job. The incumbent at the time was a 62-year-old woman. And so they made her go through the original screening interview. And there was I think a 3-person ad hoc committee conducting those interviews. And at the end of the interview with her, one of the ad hoc committee members said, "Well, thank you very much, but we really want somebody younger for the position." Needless to say, she didn't get rehired. And she then sued the association for employment discrimination. Association's defense was, well, that person didn't have any authority to act on our behalf. They're not an official representative of the association. That committee is not an official committee. We just simply created an ad hoc committee to conduct these screening interviews, and therefore we should not be held responsible for that person's statements. And the Fourth Circuit disagreed and said it does not matter what your intent was, speaking of the association. What matters is the perception of the person to whom they were speaking. And that woman had every right to believe that that ad hoc committee member was speaking on behalf of the association when he said that the association was not going to hire somebody that was older and wanted someone younger for the position. An association was held liable for employment discrimination, and my recollection is awarded damages, and the woman was awarded damages in the 6 figures. So I go through that description because, one, it's the best case I know of on vicarious liability, but it also illustrates how individuals can inadvertently create liability for the association. So the takeaway from that is be mindful when you're speaking on association business, and assume anytime a board member or committee member or manager is speaking on issues related to the association, it's going to be viewed as an official action of the association. I know a lot of board members want to say, well, right now I'm wearing my owner hat. I don't believe that exists in the law. I think once you're a board member, whenever you're speaking in association business, courts are going to assume that you're acting in an official capacity. So indemnification. So indemnification is what protects board members against claims arising out of their service in the board. So officers and directors typically are indemnified under governing documents and often by statute against claims arising from their service in the board. There are a few minor exceptions. So if, the first one typically doesn't apply in a community association context, but that's where there's an appropriation of the business opportunity of the association. The last two do. One is intentional misconduct or a knowing violation of the law. So if you engage in that type of behavior, there's criminal activity. If you intentionally defraud the association, something of that nature, you're not entitled to indemnification if there's a claim brought against you. Also, receipt of an improper personal benefit. If you're bribed by somebody, potentially, for instance, a contractor trying to get business, you're not going to be indemnified. On this question, if some of these issues come up, you're going to want to consult with counsel to see whether or not there's a provision in the documents or by statute that applies. I'll say, for instance, the Virginia Non-Stock Corporation Act includes an indemnification clause and also a limitation of liability clause for directors that requires the association to indemnify the director, except under the exceptions I noted here, and also provides that the personal liability of a volunteer director is 0, again, unless one of these extreme situations exists. Sarah, next slide, please. So common insurance exclusions. Keep in mind that the way that the indemnification is used to protect board members is often through filing a claim with a director's and officer's liability insurance carrier that provides coverage to the particular association. So the D&O carrier would receive the claim and then typically provide a letter indicating whether or not they're going to provide coverage. The following reasons are reasons that are common exclusions found in D&O policies that might cause the carrier not to provide coverage. One is defamation. So typically, although not always, a D&O carrier will not provide coverage for defamation claims brought against a director or directors. Defamation, for those of you who might not know, are claims of libel or slander, where disparaging comments are made either in writing or verbally that are not true and damage the reputation of the individual in a way that creates damages. Criminal acts, there's never going to be insurance coverage under a D&O policy if there's a criminal act involved. Claims for non-monetary damages. Most carriers provide this coverage. I know of at least one in the field that does not. It used to be fairly common that these be excluded, but about 95% of all lawsuits filed against community associations in the United States are seeking non-monetary damages. And what that means is that they're not seeking money. What they're trying to do is get a court order that either directs the association to take a particular action or that prevents the association from taking a particular action. And so it's imperative that you have that coverage. And the reason for that is to ensure that your attorney's fees are going to be covered in these type of claims. The last one I'm going to touch on are two exclusions, particulates and pathogens. So particulates, strangely enough, I've had this claim come up twice in the last 15 years for clients of mine, that this exclusion apply. D&O policies, everyone I've read actually, does not include coverage for claims that relate to dust buildup or dirt accumulation or stuff of that nature. And where I've seen it come up in my practice is when there's been a claim against an association or their board alleging that they've been breaching their duty to properly maintain the mechanical system for a condominium building, which thus has then caused the air distribution system to not work properly and allowed for excessive dust buildup in units. If that happens, you're not going to have coverage under your D&O policy. Pathogens. Nobody really paid a lot of attention to this until 2020, and then everybody paid attention to it. Up until 2020, most policies didn't provide coverage for claims arising out of disease or other pathogens, although there was sometimes some ambiguity in policies. By the end of 2020, every single ISO form for every state in the country and the District of Columbia and all the proprietary forms by the large insurance carriers have been rewritten, make clear that they were not underwriting to provide coverage for claims arising out of a pandemic. And so there's not going to be coverage for that. And which is why I'm sure a number of you engaged with your counsel back then, and you heard a lot of conservative opinions about closing amenities and being careful with how you allow people to use facilities that probably went on for several years. Okay, moving on, managing board member conduct. So here's where we talk about techniques to deal with board members. And one of them is to adopt a code of ethics or conduct. So what this is designed to do is create a standardized set of appropriate behaviors by board members, both at board meetings and also when interacting with the membership and management and themselves. I've drafted many of them over the years, typically have sections dealing with the requirement to keep information confidential. It deals with behavior at board meetings. It deals with interactions with owners and management, and often includes an enforcement provision that allows, that provides for how the board is going to regulate themselves when a board member might violate the code of conduct. Sarah, next slide, please. So here's some of the common elements, and they're basic. A lot of these provisions in the code of conduct, what you're going to find, are really based upon basic concepts of respect and decorum, right? So attend meetings and arrive on time. Review board materials in advance, both of which I also think are important with respect to the fiduciary duty. Silence devices, make certain your phones, your iPads are put on silent So there's no interruptions during the meetings. Don't interrupt your colleagues when they're speaking. Let them finish. And then that's your opportunity to speak. And frankly, at a board meeting, if it's being properly run, the individuals only speak when recognized by the chair. So the president, if it's being handled properly and the matter is up for discussion, the first person asks for permission to speak. The president or other chair allows them to speak and recognizes them. That person gets to speak until finished. And then the next board member needs to similarly request to speak. I mean, that's how it's properly handled using parliamentary procedures that govern board member and board conduct. Don't use derogatory or insulting language. Keep in mind that each person who's on the board owes a duty of respect to the board as a body, the association as the entity they serve, to their colleagues on the board, and also to the membership at large, and need to act in a way that's respectful. And as I noted earlier, please make certain that confidentiality is maintained. In my opinion, no single board member has a right to waive the expectation of confidentiality on matters that are deemed confidential. And keep in mind, waiving and disclosing confidential information can have catastrophic effects on the association, particularly when the board or the association may be involved in litigation. If I, as attorney to the association, provide advice to the board and someone on the board decides to share that advice with somebody who's not on the board, then they've waived the attorney-client privilege, and the entire discussion between myself and the board on that particular subject then is subject to discovery. So it's imperative that you keep confidential information confidential. Conduct of meetings. As I said earlier, the president typically chairs. If the president's not available, the vice president typically would chair the meeting. Many documents require rules of order to be used, while others might suggest it. Typically, it's the governing approach to how meetings are run. So, again, speak only when recognized by the chair. In order to adopt a decision, there needs to be a motion and a vote on that motion. Keep in mind, Robert's Rules does have a more condensed set of rules for small boards. And in my experience, every association I'm aware of that has a board that's small enough to use those rules. So boards can choose to use those rules for smaller boards, which actually doesn't require motions to be seconded, just by way of example. But certainly any decision has to be made by a motion and a vote on that motion. The agenda is binding on the board once it's adopted at the beginning of the meeting. In order to deviate from an adopted agenda, the 2/3 of the members of the board have to vote to deviate from the agenda and add something during the meeting. The agenda itself is adopted by a vote of a majority of the board members. The agenda would typically include a reading and approval of the minutes. Typically, there's a motion to waive the reading of the minutes so folks don't have to sit through 3 or 4 minutes of the minutes being read. At least in DC and in Virginia, there's mandatory open forum during the board meeting. I typically recommend to my clients that they adopt administrative resolutions that defines the time period for open forum and how individuals sign up for open forum. It allows them to control the meeting, ensure that open forum does not go on for an excessive length of time, and which then can distract the board and interfere with its meeting. I had a client 6-7 years ago that didn't do that, and I happened to be attending a board meeting, and they allowed open forum to go on almost entirely on one topic for 1 hour and 54 minutes. It was exhausting. Your agenda is typically going to include officer, committee, and management reports. And there might be, then once you go through that, then it's primarily the anticipated action items like voting on contracts, adopting resolutions, those type of things. Again, approved through a motion and a vote by the board, which will be passed by majority vote. If there's unfinished business from a prior meeting, you're then going to address that. And then there's an ability to have a new business section, although typically you wouldn't be raising and voting in new business on a matter that is just being brought to the board for the first time. It might be introduced, but shouldn't really be acted on. Next slide, please.
Quick question. And
Yep.
as far as the agenda layout is concerned, where do you think the best place is for an open forum?
It varies. I mean, I'll tell you, my clients typically either do it at the beginning or at the end. I would suggest that probably the fairest place to put it for the owners is probably at the beginning of the meeting. And the reason for that, it allows them to comment on stuff before the board acts on those matters. I have had clients that have wanted to put it at the end of the meeting, frankly, because their desire is to reduce the number of people that speak, and people often are not going to stick around to the end of a 2-hour meeting just to speak. But if, from an objective standpoint, looking at sort of the intent of open forum, I would typically recommend having it at the beginning.
Thank you.
Sure. And here, some of what I just said is set forth here. Once the agenda is adopted, it can be deviated only by a vote of 2/3 of the director. Oh, this is a great point. On matters that have been voted on previously by a board or committee, it can only be reconsidered and acted upon again if there's a formal motion made by a director who was in the who voted in favor of it previously, and that vote passes by 2/3 vote. So there's two elements to it. One of the people who voted yes has to then make the motion to reconsider, and 2/3 of their colleagues have to vote in favor of it, including themselves. Next slide, please, sir. So leadership skills. I mean, that's what a lot of this is about. We're talking to you all because you all are leaders of your community, and getting some guidance on how to deal with issues once there's some conflict. So how do you deal with that? How do you reduce conflict? And how do you serve as an effective leader of your community? One, try to act together. Try to get consensus to the extent that you're able to. Act as a team. Be positive. Do not be continuously negative on the association and how it's acting and how it's operating. Be constructive in approach. If there are things that need to be fixed, of course, try to fix them. But don't simply criticize without acting. Listen. Owners, it's important to understand what people are thinking about the association. Listen to them. And when appropriate, take appropriate action. But manage your expectations. Make certain that it's not uncommon for people to want whatever their particular priority is to be addressed then and there, and supplant anybody else's agenda. So manage that. If the right answer is thank you, you've raised some great points, we need to look into it further, and then once we have a better understanding, we'll take some action on it. But that might take 6 weeks or whatever it is. Say that. Don't let people think that you're going to do something immediately and then not do it. And also don't be afraid to get advice from owners or others, and don't be afraid to give feedback. Accept criticism. None of us are perfect, and none of us are right. Every time, despite what we might want to think of ourselves. So don't be afraid when someone says, you know what, that really didn't work very well. Maybe you should think about this. Receive it and consider it. I think communication between the board and the membership and amongst the board members is critical. It doesn't work very well if board members who disagree refuse to speak to each other, because one thing that's guaranteed of that is we're going to continue to disagree. And work the issue, not the person. Sometimes that can be difficult when people can become nasty or and personally attack them, but try not to let that get into the way when you're making your decisions. So dualities and conflicts of interest. This goes back to concept Brett spoke about about 20 minutes or so ago when he was talking about the duty of loyalty. So, as Brett noted, all directors owe what's called an undivided duty of loyalty to the association. And that means that they need to put the interest of the association before all others, including their own. So that means that directors must strive to avoid personal conflicts of interest. This includes, engaging in nepotism or providing themselves with personal benefits. It means not granting contracts to the companies owned by their neighbors, their family members. If there's a potential conflict, then the director is required to disclose that conflict to the other people on the board. If a director believes that their conflict does not rise to the level of a conflict, or that their interest doesn't rise to the level of conflict, and doesn't interfere with their ability to exercise their duty that they owe to the association, then they're required to state their reasons on the record and their intent to participate in discussion on the vote on the motion. By the way, directors that do that are doing so at their own risk. So if they have a conflict or refuse to recuse themselves, then they expose themselves to claims of possible breach of duty. When a conflict exists, then directors should recuse themselves from the discussion and vote on the issue. When I'm conducting trainings for my clients, I typically recommend leave the room while it's being discussed. You want to remove any allegation that you improperly influenced your colleagues on the board to vote on a matter that you have a conflict. And frankly, that's to protect the board member from allegations of a breach of duty. If you're not in the room, it's very hard to say that they didn't follow their duty by recusing themselves and not participating. So that's a suggestion. It's not required by law to leave the room. I just think it's the best way to protect yourselves against claims of impropriety in the future. Next one, Sarah, please. Thank you. So here's some examples of conflicts. When the board intends to review a case involving compliance of a board member with the association's governing documents. When the board is considering a contract with a company that the board member owns or a family member owns, those are clear, direct conflicts of interest. And so board members shouldn't be voting to approve expenditure of funds for contracts that are granted any member, any relative or of the board member or any entity that's affiliated with any of the members or their relatives. Unless the board engaged in that disclosure. Keep in mind that any vote on that requires a 2/3 majority, not a majority. Also, if it's later determined that a conflict existed, then the person who has a conflicted, who is in the position of conflict, their vote is deemed void. Sarah, next slide, please. Enforcement. So these are often written into codes of conduct. When I write a code of conduct, I have an enforcement section that includes the mechanism by which the board will enforce their code of conduct. And it typically has stages, either based upon the frequency of violations or the severity of the violation. So sort of the least severe is a private reprimand. Then you might go into public censure, where not only is there a private reprimand, but there is the person might be publicly censored on the record of the board meeting. Also, there might be a letter that might correspond with that, indicating the public censure. You also might have a letter with respect to a private reprimand. Request to resign, and this is where you start getting into severe behavior. So the request to resign, could be also followed by, if they refuse to resign, the board initiating the process to have the membership vote on their removal. You also depending upon the language in your documents, if you have authority to suspend a member's right to use various facilities and amenities, you may be able to apply that if there's a violation of the code of conduct. Because keep in mind, a code of conduct is a rule of the association. But you need to have the authority in your documents to permit that. And potentially impose fines for violations after notice and an opportunity for a hearing. You could do that as well. I would say that in my experience in these, most code of conduct violations that I've been involved with have either involved a private reprimand or a public censure. And typically I recommend before any action is taken that a hearing before the board in executive session be conducted to discuss it for two reasons. One, I think that there's a degree of due process provided. The other, in addition to ensuring that due process is provided, that also allows there to be the dialogue between board members that may sensitize the person who may have violated the code as to why their colleagues found that to be inappropriate. And because there are times where people don't recognize that their behavior is inappropriate, and that's why action's being taken. So that's typically what I suggest to my clients there. Best practices. So here we go. Adopt code of conduct. Many of my clients do. I believe a number of Brett's do. But I have some clients that don't have it. I've had one client that was opposed to it. But I do think it's the best practice. Conduct annual board training. A lot of my clients do. I had one on Tuesday night. I had two the first week of the month. I think the only reason I didn't have one last week was because I was at the National Law Seminar in California and was not in a position to conduct a board training. But they're coming up for me, at least, frankly, I'm doing about 3 or 4 a month in my practice. And I think it's important. It's good for board members, even if they've been on the board for a while, to get a refresher. Also, the law does change from time to time. Also, best practices might evolve as we learn more, or there's changes in the law, or changes in the interpretation of law. So I recommend to my clients that they have an annual board training. In my board trainings, I touch on the next bullet point: minimize the email debate. So most documents allow board members to vote on matters in what's called an action outside of a meeting. It requires typically unanimous written consent of the board. I recommend to my clients that when you do that, simply circulate the motion without comment and try to minimize the email debate, because keep in mind, your email debates are not going to be privileged and confidential if you end up in litigation. It will be subject to discovery. So please minimize the amount of back and forth on issues by email. The Community Associations Institute adopted a civility pledge several years ago. It's helpful, I think, to be aware of it, read it. Signing it, it doesn't really create additional liability for a board member, but what it does do is it provides sensitivity to the various issues that we're talking about in this presentation. Attend industry educational sessions like this, or it might be conducted by Community Associations Institute, by your law firm or others. If there's a particularly egregious case, you might want to bring in a third party to try to mediate. I've had to do that a couple times in my practice in the past. It doesn't happen very often. It's typically when board members are unable to really reach any degree of commonality amongst themselves. And that is the end of the slideshow.
Okay. Well, thank you so much, Todd and Brett. We do have a few general questions in the chat. If you have a question, feel free to pop it in. We do have about 10 minutes left for Q&A. Slightly off topic, but I think a fair question. For rules and regulations or bylaw violations, DC code supersedes board governing docs. Rules and regulations should match DC code. Fines for violations can be imposed if no hearing was requested by the unit owner.
So the DC code includes very little language actually on the ability to impose fines. What it says, and I actually think I might have it on my computer because been working all day. It allows for the impositions of fines following notice in a hearing is, I believe, the language. Let me verify that precise language. The language is found in section 42-1903.08 of the Condominium Act. And that's the section that governs. So we're focused right now on the Condominium Act. If it's a property owners association or if it's a cooperative, then you're going to need to rely solely upon the language in your documents. If it's so the statutory language is provides the authority to levy a reasonable fine for a violation of the condominium insurance or rules and regulations of the unit owners association. That's essentially the language. It does require notice and an opportunity for hearing, and does not say a lot more than that. So I will tell you my recommendation to my clients. My recommendation is you provide them notice of the violation, and you provide them with an opportunity to be heard. And that's what statute requires. There's some that will interpret that to mean, well, if they don't ask for it, they don't get the hearing. What I typically recommend to my clients is you indicate to them that that they have an opportunity for a hearing, and if they do not request a hearing, do not appear, a hearing will be held in their absence. Because to me, that's the belt and suspenders approach to it, to ensure someone can argue that, well, I didn't really have an opportunity for a hearing. There's different interpretations. Mine's probably conservative, but I'm trying to eliminate challenges. So when you ask about whether or not rules and regulations should match the DC code, I mean, keep in mind the DC code just says notice an opportunity for hearing. I typically recommend to my clients that they have a complete enforcement and due process policy that sets forth process and procedures. Again, because I want there to be no allegation that the board failed to provide proper notice and provide an opportunity to cure and a notice of hearing. So that's my recommended approach.
Got it. Thank you so much. Can a managing agent enforce a board president to require meeting minutes and votes to be taken and recorded? I know as a community manager, we do and always promote best practices, but as far as forcing somebody to actually record meeting minutes, I know EJF does not record meeting minutes. We're not a part of the board. We're not a secretary. So what, in those instances, what type of advice would you give a board member when a president is not following best practices?
I think you need to notify the entire board as to the requirements. The Robert's Rules Order clearly requires meeting minutes, and the statute requires meeting minutes to be taken. So keeping meeting minutes is not discretionary.
Mm-hmm.
If a president is unwilling to comply with their legal requirements to keep meeting minutes, and they want to conduct business via text message, the rest of the board should object. If the person won't comply, the governing documents allows the board to remove someone from their officer position by majority vote. At least every set of documents I've ever read allows for that. And so if you have a president who refuses to conduct business properly in accordance with the law, then if I were on that board and I want to protect myself from claims I've breached my duty, I'm talking to my other board members about removing that person from the presidency and putting somebody in that position that will comply with the law.
Yeah. Okay. Thank you. And then can the managing agent enforce meetings to be public and open to owners for attendance and announcements in advance when most of the board members prefer to have them in private? Well, the DC Condo Act speaks to that, right?
Yeah, well, I mean, both in Virginia and DC, at least my experience, and I don't practice in Maryland, but I believe the laws in Maryland is similar. Meetings have to be open to the public. meaning the other owners. It's not permissible for a meeting to be entirely private. Now, there's an executive session provision in both DC and Virginia that allows certain issues to be discussed in private. But much of what's discussed at a board meeting and acted on a board meeting is required to be, owners are required to be permitted to attend. And if a board is making decisions completely in private that are required to be made in public, then all of those decisions are voidable. They're subject to challenge because they were not adopted properly. There is both the Virginia Condominium Act and Properties Association Act, for instance, include language that states that there is no voting in executive session. Every single vote has to be on the record in open session in Virginia. In DC, you can vote in executive session, but the meeting minutes have to reflect the vote. And both jurisdictions only limit what can be discussed in executive session to a limited number of topics. Maryland also has similar law that restricts what can be discussed in executive session. Brett, do you have any other thoughts on that?
I don't. That's well said.
Yeah. One of the things that, because annual meeting season, we're starting a new year, that I find helpful just with boards is, would you have a recurring like monthly board meeting to just set your schedule in advance and then publish it to the entire community, as well as most board meetings are now held via Zoom, or maybe you always have a meeting in your lobby, but like in that notification provide either that recurring Zoom link or the meeting place, so this way the public, the ownership is well informed in advance, as well as members, so there's no conflicts trying to schedule a meeting the last minute, and all of that.
Yeah, Sarah, I think that's a great way to satisfy the publication requirement that's in the statutes.
So, okay. I'm not seeing any other questions. You guys have any final advice for brand new board members, as I'm sure plenty of boards were recently elected in the last few months?
Ask questions. If you don't know something, don't be afraid to ask management, more experienced board members. Even ask for advice from counsel about things that you might have questions about. Don't be afraid to be inquisitive. And be respectful and listen to folks.
Well, thank you both so much for your time today. I greatly appreciate it. And thank you, board members, for taking time out of your busy schedules to spend an hour with us going over this important topic. All right.
Thank you.
Thank you all.
Sarah, if you need anything else from us, let us know.
Certainly will. Bye.
All right. Take care.